Morning, everyone. I'm Matt. I'm here with my colleagues Toby and Fiona to talk about whistleblowing. A couple of administrative points to start with. First of all, this webinar will be recorded, and after the webinar, you will get a copy of the recording and a copy of the slides. Secondly, if you have any questions, please post them in the Q&A function, and if we've got time at the end, then we'll pick up those questions. Admin out of the way then, so on to whistleblowing. Now, I think whistleblowing has an image problem, and I think its image problem starts in childhood. Tom, if you could pop to the first slide, please. One of the first lessons we are taught as children is don't be a telltale. And we're taught that for good reasons. Group harmony is important for survival. Children can't tell the difference between, when they're told rules, between a minor infraction or an important issue. And so, for quite legitimate reasons, we don't want all of our time being consumed by children reporting minor infractions about what their peers do. So we tell them, not just in Western culture, it's a fairly universal thing, don't be a telltale. And I don't think it's too much of a stretch to say that that early lesson then informs our general attitude to telling tales and, for want of a better term, to whistleblowing. So there is a risk that that impacts on our approach to whistleblowing. Employers automatically, historically, have felt it's a bad thing. Employees are scared to do it because of the potential consequences they fear. So it has an image problem. What we have found in recent years is that more employers, particularly in certain sectors, are recognizing the importance and benefits of a transparent culture and the importance and benefits of a culture in which people feel prepared to whistleblow. The survey we carried out at the beginning of the year, which is the reason why we're covering this topic today, indicated that in terms of HR initiatives in various areas, healthy living, hybrid working, team building, etc., remained relatively constant in terms of people telling us that's what they were doing between 2024 and 2025. The one area where we saw a big uplift with employers was saying in 2025, we are going to be doing more about whistleblowing initiatives, which we thought was interesting and perhaps a sign that employers are looking to embrace a whistleblowing culture more. Tom, if you could pop to the next slide, please. So in, well, it was a while ago, I think in 2023, the government commissioned a report from Grant Thornton as to the effectiveness of the current whistleblowing framework in Great Britain. And they were assessing the whistleblowing framework against these purposes that were the original purpose of the legislation. So to provide a route for workers to make disclosures, to protect workers who've made disclosures and provide a route of redress where detriment or dismissal happened. And then this third point, which is what I was alluding to support wider cultural change in which the benefits of whistleblowing are recognised. Now, some of the statistics that we see coming out about whistleblowing aren't particularly positive, aren't great. So one I've seen is more than 25% of workers are aware of some misconduct or wrongdoing in their workforce. So more than a quarter. More than half of those who are aware choose not to report it. And only a quarter of reports are investigated, dropping to 10% in some sectors during the pandemic, which aren't particularly positive statistics. So that was the reason why the government asked for an appraisal of the current framework. And at the end of this webinar, we'll talk about some potential reform in that area. What's going to happen next is Fiona and Toby are going to take us through the current legal framework and the current law around whistleblowing, so we're all aware of that. But it's important, I think, to explore that through the lens of understanding this drive towards a wider cultural change. So I'll pass on now and we'll look at what the current law says in this area.
Thanks, Matt. Hello, everyone. So I'm going to look at who is a whistleblower and what a protected disclosure is, because that's kind of the first part of the legal test. Generally, disclosures will be, I think the cases that I've dealt with have been to the employer, but a disclosure can also be made to a legal advisor, a government minister, a prescribed body or person, or any other person or body, e.g., the police or media, but there has to be a good reason or be related to an exceptional serious failure. So that's who the disclosure is to. And then the first part is there's going to be a disclosure of information. So it's not just a general allegation. There must be some facts behind it, and that can be orally or in writing. And in the case of Cavendish Monroe, the EAT gave some helpful guidance in terms of distinguishing whether something is actual information or just a general allegation. So the example given is the wards have not been cleaned for the past 2 weeks. Yesterday's sharps were left lying around. You are clearly communicating information when you say that. Contrast that with you're not complying with health and safety requirements. And the ET said that was an allegation, it wasn't information. But the case law has gone on to look at that further. So it's quite clear the distinction between the two, but you also need to look at the context, because if you had a situation where the comment was made, you're not complying with health and safety requirements, but the worker took you to the ward, showed you the sharps lying around when they made that statement, then it gives some context behind it. So you look at what is said, but you also look at the factual context behind it and see if there is sufficient detail behind it so that it amounts to a qualifying disclosure. Because certainly in that instance where you made a general allegation, but you took them to and showed them whatever you're alleging, then that may well be enough to constitute a qualifying disclosure. Another thing to just note in relation to disclosure of information is that employees should be careful, because sometimes, and I've seen this in cases, employees go further than purely making a disclosure, and they may end up committing an act of misconduct or gross misconduct when they attempt to find evidence in relation to that. And the whistleblowing legislation doesn't necessarily protect that conduct. There was one case called Bolton School and Evans in 2006 where a worker said to their employer they believed the IT system was not secure. They then went one step further to obtain evidence of that and hacked into the system, and the employer then took the view that that was unauthorized, and it constituted misconduct, and the employee was given a warning. And the tribunal held that the hacking was part and parcel of the disclosure, but the Court of Appeal overturned that decision and said the hacking was a separate act which was not protected by the whistleblowing legislation. So I think both workers and employers need to proceed with caution. The lesson is if evidence falls into the worker's hands, its disclosure may be covered by the whistleblowing legislation. But if workers kind of go digging around for stuff, they could inadvertently end up in a disciplinary, and that may not be protected by the whistleblowing legislation. And conversely, employers need to be cautious. Misconduct doesn't automatically remove a whistleblower's protection, and a tribunal may still find that the protected disclosure and not the associated misconduct was the employer's real or principal motivation for any disciplinary action. So, something to bear in mind. So, one, there must be a disclosure of information. Secondly, there must be a disclosure of information about unlawful activity, and we've listed the six types of unlawful activity. So, a qualifying disclosure must be a disclosure of information which, in the reasonable belief of the worker making it, tends to show one or more of these six specified types of malpractice, wrongdoing, or a failure. Has taken place, is taking place, or is likely to take place. So it's quite wide if you look at those six categories. And it can be past, it can be present, it can be prospective, it could be alleged. It can concern the conduct of an employer, an employee, or a third party, and it can occur inside or outside the UK. And when the employee makes that disclosure, they don't have to state at that time that they reasonably believe that their disclosure tends to show one of those six things. They don't have to identify a legal obligation. That might be a factor that the tribunal look at further on down the line, but they don't have to specify that at the time. So we've got a disclosure of information about one of those six unlawful activities, and the individual must also have a belief, a reasonable belief in the unlawful activity. They must have a reasonable belief that the information disclosed tends to show one of the relevant failures or acts of wrongdoing. They don't they don't have to prove that the facts disclosed are true or that they're capable of amounting to one of the categories, as long as they believe the relevant failure has occurred or is likely to occur, and the tribunal view that as reasonable. It doesn't matter that subsequently it turns out that that was wrong, or that the facts alleged would not amount in law to the relevant failure. So there is a real distinction there, and it's important to note that the wording of the legislation looks at the worker's reasonable belief, and that it specifically needs only be that the information disclosed tends to show the relevant wrongdoing has occurred. Because there's a distinction between saying, I believe X is true, versus I believe that the information tends to show X is true. And that's the key, really, that the worker reasonably believes that the information tends to show one of those six types of unlawful activity, and if that is the case, then that will be a qualifying disclosure. Now, the wording as well of the legislation in section 43B1, it refers to a disclosure of information which, in the reasonable belief of the worker making the disclosure, tends to show wrongdoing. So there's both subjective and objective elements of that. And the case law has said that those with professional or insider knowledge will be held to a higher standard in terms of what is reasonable for them to believe, because they're more informed. And that can work both ways. So someone with experience in the field has information or insight which entitles their views to respect. That person should also be expected to know better than a layperson when something is truly amiss. And that's also taken into account. So something to bear in mind. The final element of this kind of four stage test in whether a protected disclosure has occurred is that there must also be a reasonable belief that the disclosure is in the public interest. And in terms of what amounts to the public interest, this was a test that was brought in 2013. The significant case which you may have heard about is Chesterton and Nur Mohammed, which looked at what public interest means. The issue being, in a whistleblowing case where the disclosure relates to a breach of a worker's own contract of employment or something of a personal interest, you wouldn't necessarily think that there is a public interest there, but there might be features of the case that make it reasonable to regard the disclosure as being in the public interest as well as in the personal interest of the worker. And the Chesterton case highlighted this. That case, Chesterton's were an estate agent. A senior manager at Chesterton's raised a concern about the manipulation of company accounts, which he believed had had an adverse effect on commission income for over 100 senior managers, which included himself. And yes, there is that personal interest there in this case, but there was also the wider interest for the other managers because of this alleged manipulation. Now, the Employment Tribunal upheld that the disclosure was a qualifying disclosure, that this public interest test was satisfied. The employer appealed against that, and that appeal was dismissed. And they discussed having a four-factor kind of approach in terms of determining whether a case there is this public interest element is satisfied. Number one, the numbers in the group whose interest the disclosure served. Clearly, the larger the number of people affected, then it's more likely that there'll be other features which will engage the public interest. Secondly, the nature of the interests affected and the extent to which they're affected by the wrongdoing disclosed. So, where the wrongdoing affects an important interest, it's more likely that that's going to be in the public interest versus something that's trivial or marginal or indirect. Thirdly, the nature of the alleged wrongdoing. If it's a deliberate wrongdoing rather than advertent, then it's more likely that would be in the public interest. And finally, the fourth element is the identity of the alleged wrongdoer. The larger or more prominent the wrongdoer, then the more likely it may be that the activities could engage the public interest. Although it was said that that principle shouldn't be taken too far. Now, in the Chesterton case, the court held that there were factors besides the number of employees affected that did render the disclosure in the public interest, namely that there was a deliberate wrongdoing, which took the form of financial misstatements on a substantial scale. But the courts were really wary of not opening the floodgates by this type of claim. And specifically, the judge did say that, they didn't want this to be a route to aid private workplace disputes via whistleblowing claims, even those involving large number of employees where none of the other factors are present. So I think do bear that in mind when we're looking at the public interest test. And if there is a personal element to that, I think you need to look at then the numbers affected, but if there are any other factors, because that will mean that it is more likely to satisfy this definition. If we go on to the next slide. And this, as I said, despite the legislation being called the Public Interest Disclosure Act, the public interest element was only introduced in 2013. Now, that was introduced to reverse the decision in Parkins and Sodexo, because in Parkins and Sodexo, the EAT held that the definition of qualifying disclosure was broad enough to cover a breach of a whistleblower's own contract of employment, despite the fact that it didn't appear to have this public interest element. And you can see that would raise alarm for employers and legal advisors, because you might see employees who are at risk or consider themselves at risk of dismissal making a tactical disclosure alleging breach of their own employment rights, with a view to then later bring in an automatic unfair dismissal claim, because of course qualifying service is different, there's no cap on compensation. So the public interest element was introduced, namely to reverse the effects of Parkins and Sodexo. But obviously be aware that, yes, we do have this public interest test, but following Chesterton, a breach of an employment contract might still be in the public interest. We need to look at the numbers affected and whether the other elements of those four factors are satisfied. In terms of breach of legal obligation, just a few other things to mention. It could be breach of a contract, a worker's own contract, if, as I say, those other elements are satisfied. It could also be by reference to breach of a statute or a regulation, but it does have to be more than a belief that certain actions are wrong. There was a case, Eager Securities and Caution Over, where a claimant had made a disclosure that the MD of the company was sending emails under her email. She said that that was wrong, it was misleading, and she believed that there was an obligation, a legal obligation, that the company shouldn't be doing this. Um, and the EAT in that case said that wasn't an obvious case of a breach of a legal obligation, and the tribunal should have identified the source of that legal obligation. So you do have to be careful in terms of it's more than a belief that the actions are wrong. It's not a breach of guidance or best practice or a moral obligation. And I think you can contrast that with that case of Bolton Schools versus Evans, which I talked about earlier, where uh, the individual believed that the IT system was insecure and therefore hacked into the system. Clearly, in that case, it's more obvious that private and sensitive information could get into the wrong hands as a result of the system insecurities identified, which is slightly different because there's more of an emphasis on there being a breach of a legal obligation. It was more obvious in those scenarios. And the other cases that have looked at breach of legal obligations, have included things like defamation as well, and also harassment. And I'll hand on now to Toby, who's going to cover the next section.
Wonderful stuff. Thanks so much, Fiona. So we've now gone through how you make a protected disclosure. When you are then protected, what happens? So when you make a whistleblowing disclosure, they achieve two separate sets of protection. They're both on the screen there. So one is detriment, a protection from being subject to a detriment because you made a protected disclosure, and the second is then dismissal. So I'm going to look at these kind of in turn here. So a detriment itself, right? So if you make a protected disclosure, you have a protection from being subject to something that puts you to a disadvantage or to a harm on the ground that you made that protected disclosure. Key thing, if you make a protected disclosure and you're subject to something because of that, then you are protected. It can be that you're subjected to other adverse events, not because of whistleblowing. And that's obviously the essence of quite a lot of the cases that we see, whether or not that person has been subjected to something because of that whistleblowing disclosure or not. But if you look at detriment in this context, as I say, it's anything kind of disadvantage or harm that that person might suffer. So it can include things like being bullied, harassed, or ostracized because you made a disclosure, being denied promotion or training, having disciplinary action brought against you, having a reduction in your hours or pay or loss of bonuses, or being sidelined or excluded from projects. And the whistleblowing itself must have more than a trivial influence on the treatment that's been meted out. So you're going to see this quite a lot. I mean, these are the essence of like the vast majority of whistleblowing claims. It's, I did this thing, I should therefore achieve protection. And then look at all these bad things that happen to me thereafter. And it's this kind of causes of bridge, this kind of souring event that takes place. And that is very easy for then an employee to show. Say, look, I did this. And then directly after that, I was subject to disciplinary action. Or directly after that, everyone treated me really differently. And that's a detriment. Right? And that's separate to a dismissal. So detriment can't be a dismissal, right? They are two separate things. But a detriment, what it does in an employment tribunal, it gives the individual a right to bring a claim for injury to feelings. So that the same award that you get for discrimination, it's the same term, and it is very much an award that penalizes an employer for the injury that they've subjected that employee to. So in the same way as discrimination, don't treat me less favorably because of a protected characteristic. In this respect, it'd be, you subjected me to this because I did a whistleblowing disclosure. My feelings were injured by that, and therefore I'm entitled to a sum of money. And again, in the same band as you would get for discrimination. So that's separate than dismissal. So dismissal itself, an individual is unfairly dismissed if they're dismissed for the reason of making a protected disclosure. If there's more than one reason for their dismissal, i.e. they've done something wrong, but they've also made a protected disclosure, misconduct of some sort, then the principal reason for dismissal has to be the whistleblowing disclosure. Again, that's something that you look at in an employment tribunal claim and scrutinize what was the actual reason. Was it the misconduct, or was it this earlier protected disclosure that had been raised? If you're found to have been dismissed because you made a protected disclosure, that is an automatically unfair dismissal. You can have the fairest process in the whole wide world, beautiful letters, wonderful policy, everything's gone smashingly, different officers at each stage, brilliant. Doesn't matter. If you've done it because of whistleblowing disclosure, it's automatically unfair. There isn't an argument at any point about whether it's unfair or not. It just is. There is no cap on compensation awards for protected disclosure claims either. So it can be full life loss. You do tend to see that certainly with whistleblowers in, regulated sectors. Say, I blew the whistle, they dismissed me. I'm not able to get another job because they keep slagging me off my references, saying that I'm a troublemaker, saying I'm a tattletale, to use Matt's wording. And they say, well, actually, I'm going to suffer loss for the rest of my life. Now, the tribunal don't tend to crystal ball by more than a couple of years like that. Say, well, you're probably more likely to get a job, or you can go do something else, et cetera, et cetera. But say in financial services, it can be that those awards are absolutely massive, or at least the very claims that people put in are absolutely massive. But that's the real protection that comes from it when you come down to whistleblowing. Now, there is also this really unique part of award, this thing called interim relief. Interim relief is an absolute roller coaster to go down. Interim relief, what it says, it's a really, really powerful remedy. It's available in a couple of instances, and one of the key ones that we see is with whistleblowing. So what interim relief does is this temporary order by an employment tribunal that protects a whistleblower. But there's some really, really strict rules about how it's operated. So say if someone gets dismissed, right, and they say, I was dismissed because I was whistleblowing, they've got to bring a claim to the employment tribunal within 7 days of being dismissed. There's no extension. No, it has to be a hard line 7 days. You're a minute out, and you lose the right to bring the application for interim relief. There's no requirement to go through ACAS early conciliation. This is one of the exemptions from that. So what you say is, in essence, I got dismissed. I believe it's because of whistleblowing. I want an order for interim relief, right? So it's 7 days between them being terminated. They have to put the claim in. And then normally, depending on which tribunal you're in, an employer will get somewhere between 7 and 14 days notice of that hearing. It's an expedited hearing. So it could be application comes in, 7 days of them being dismissed. 7 days later, you could be in a tribunal hearing, but it's normally a half a day hearing to determine whether or not that person was dismissed because they whistleblew, right? It's a powerful remedy because there's 3 orders that a tribunal can award. The first one is reinstatement. So the employee is entitled to return back to their old role. I mean, not even looking at the financial elements of that, how awkward is that? You've just terminated somebody and you've told all the staff not to worry, this person's gone. And then 14 days later, they're entitled to come back to work and sit in work whilst the ongoing application of their employment tribunal claim is going. Right? I mean, that itself is pretty powerful in itself. The reinstatement's one, re-engagement's one, they return back to the exact same job, they return back to a similar or a comparable role. And then the most common one, which is contract continuation, which just means that employee is entitled to be paid throughout the time from the award is made up until the date of the final hearing in full, with no requirement to attend at work. So they are in essence on garden leave, they're kind of suspended, etc. It's very, it's analogous to that, but it's not those things. What that person is entitled to is full pay for that period of time. And say, again, depending on which tribunal you're in, if you're in any of the southern tribunals, it could be a couple of years before you get to your final hearing. You get awarded interim relief within 14 days. Your hearing is not for the next 2 years. That employee is entitled to 2 years of full, unadulterated pay up until the final hearing. If they get to the final hearing and they lose, so their claim is found to not be correct, they haven't been dismissed because they whistleblew, there is no obligation on them to pay back that money. So again, it's such a powerful remedy for the employee to achieve, but it is an exceptionally high bar for them to get over. So the tribunal has to find that it's likely that the dismissal was caused by the whistleblowing. And it likely in this context means a pretty good chance, not just more likely than not. And these types of cases, they're given real heavy scrutiny by an employment tribunal. I've done quite a number of them in my practice, always for employers, and I've never seen a claimant be successful in it. It seems to me that it very much has to be, I'm whistleblowing, and the employer says, well, I don't like the fact you're whistleblowing, I'm going to dismiss you because you whistleblew. If there is a case to be heard or any type of other issue that might need further evidence, etc., then the tribunal is less likely to grant that application. Now, again, interim relief, absolute wild ride, because within that 7 day period, when you get that notice, an employer has to be able to create almost a full claim. They have to get all the documents together, they have to get all the witnesses together, do witness statements, file it up there. So again, if you're going through that process, you're going to be terminating someone where they might have done a whistleblowing claim. Always a good idea to take a bit of advice prior to dismissal, or at least if you're going through it, make sure that the dismissing officers are clear in the reasons why they're making that dismissal exercise. And if it is very much a case of, well, we're not quite sure where we are with it, best to be quite cautious and make sure that there's a focus on some sort of misconduct or poor performance or an alternative reason for termination that isn't obviously whistleblowing. You can see from the slide on here, I didn't touch on it at first, but the detriment claims can also be made by an individual against another individual. So this is from a case, it's Timis and Osipov, right? And before this case time, normally it's just employees bring claims against their employer. Fine. Harassment claims can be brought against an individual as well. But in Timis and Osipov, what happened was this chap called Osipov, so he raised a protected disclosure. And there are two non-executive directors who behind the scenes got this protected disclosure, and they're like, we don't like this, we don't like this. So what they did, they engineered the dismissal of Mr. Osipov. So Osipov brings a claim against. He said brings a claim against the company, which is International Petroleum Limited, and also these two non-executive directors, one of whom was Timis, right? And what he says was, there's a difference between dismissal, which is the act that the employer subjects me to, and a detriment, which is the act that anyone involved in my dismissal could be brought by, or bullying me, or harassing me, or subjecting me to disciplinary action. And what he said in that claim was that because there are these two remedies, that means that whilst an employer has to be responsible for dismissal, there can be no argument about that. Anybody else, any other individual who's involved, can be personally liable for the detriment action, so it's entirely separable. It wasn't really something that we'd seen before. It's a kind of a bit of a unique aspect of the way in which that law was to be interpreted. The Court of Appeal and the Employment Appeal Tribunal both completely agree with that point. And they said, yeah, individuals can be liable if their actions cause somebody to be terminated. And causing someone to be terminated is a detriment, and the actual termination itself is our dismissal. So there's two separate actions. It's a bit unique here because normally there's an employer that you're going against, and it's a solvent employer. In the case of Osipov, International Petroleum went insolvent, so there was no one to claim against. So he was suing the two non-executive directors for the losses that he would otherwise have suffered. And the employment tribunal agreed with him, and the loss in that case was £2 million. So again, it's like that's obviously a really stark warning for people who are going through that process to make sure that your decision making as you're going through the dismissal exercise isn't tainted in any way by whistleblowing. Because if it is, you'll be personally liable. And if the losses are massive, most people have paid quite a lot of cash. If the losses are massive, you can be personally liable for those losses as well. Normally, employees, they're going after the employers, because an employer or a company generally has deeper pockets than the individuals involved. Tom, could you go to the next slide, please? So I'm just going to look a bit more at causation. So, when's whistleblower detected? What causes the dismissal and the detriment? There are two really interesting cases that set out here, right? So you've got Duty and Royal Mail Group. So what happened here was Miss Duty, she was a probationary media specialist at the Royal Mail. And she made a protected disclosure about breach of Ofcom guidance to her line manager, right? It's a separate person, right? So her line manager got that whistleblowing, did a number of things. He pressured her to retract the allegations. In essence, what he did thereafter was then to fabricate a narrative that she was actually poorly performing. What a rotter, right? So he creates this narrative that she's poorly performing. But the way that the Royal Mail Group is structured is big enough that what he does is he sends this narrative of poor performance to a separate manager. This is a lady called Miss Vickers, right? So Miss Vickers is dealing with the poor performance improvement plan, determines that actually there is evidence of poor performance. She uses the rotten apples information from the line manager to come up with the decision making that actually there should be a fair reason for this dismissal. And what Duty does is she says, well, actually, I raised a whistleblowing disclosure to the line manager, right? He creates this narrative that I'm poorly performing, and that's a poison apple that then spoils the bushel because Miss Vickers can't make a reasonable decision on the basis of this earlier bad information, this false information. And what Miss Vickers says is, and what the Royal Mail Group say is, but Miss Vickers got absolutely no knowledge of the whistleblowing at all. So how can she or the Royal Mail Group be liable for detriments or dismissals because of something that was not in their knowledge? And again, on its face, you read that and you think, yeah, okay, fairly reasonable, I guess. You don't know about a thing. How can you take that into account? How can you subject someone to a detriment because of a whistleblowing disclosure that you don't know about? But what the Supreme Court says was, no, there's a nefarious guiding hand, unseen, behind the scenes that no one knows about, and that is sufficient to look through the reasons why this all came about. And you're going back these numbers and numbers of steps, and you're saying, well, yeah, this procedure here might have been fair, and yes, you might not have knowledge, but the actual amoral puppet master behind the scenes, this line manager who gets a whistleblowing disclosure and decides to create the false narrative, that is because of whistleblowing, and everything else waterfalls because of that. And again, it's not something we've really seen before. Before that, a lot of claims get brought by whistleblowers, making certainly making assertions of things like conspiracies, or I've said this, and therefore everyone else must know about it. But a lot of the time they failed on causation because the person didn't know. They might say, I had no way of knowing, I had no inclination to suggest that had taken place. That person had not talked to me about it. Therefore, I couldn't have taken it into account. Fair, reasonable, understandable. But what duty says is what the employer then has to do is to be aware of where that information is coming from and what has happened at each stage. It's a pretty unique case. It's not something that we've ever come across before 2020, but it's just a really interesting one to kind of say, well, what was the cause? What's the fundamental cause overall of that person's termination? If it was whistleblowing, you're still protected. Again, pretty powerful. Kong and Gulf International Bank is the other one on the slide there as well. Kong, again, super interesting. So Kong is she was a head of financial audit at Gulf International Bank, and she raised concerns about the legality of a financial project. Right? She made a protective disclosure to the head of legal, but the head of legal took offence. Right? And they said that the implication from what Miss Kong was saying was that the head of legal believed that the allegation was against them and that they were acting unprofessionally. Now, Miss Kong was later terminated, right? Classic, right? She was terminated, and the employer said, it's not because of anything else, it's because of your interpersonal style. The way in which you went about this is what caused you to be terminated, right? It was the way in which it was communicated, how you delivered that message. That's the reason for the termination. We didn't care about the protected disclosure. Happy for you to make disclosure, happy for you to complain about things that are going wrong. We just didn't like the way that you did it. And you'd think from all these other bits of case law that actually the tribunal would have seen through that and be like, look, you can't separate these two things. That's not what Kong says. What happened with Kong is that when she was dismissed for standards that fell short of professional behavior, that was the principal reason for termination. And the Court of Appeal said that you don't just get blanket protection overall when you're a whistleblower. So you don't get to say, I'm making this whistleblowing disclosure and all you guys are a bunch of jerks at the same time. You don't get the protection thereafter. It's not something that's this huge shield around you for any other type of misconduct. You can still be terminated for things that are entirely fair to terminate you for, even if they're mixed in with the protected disclosure itself. Obviously, pretty unique case on its facts. Be interesting to see what happens and applicable to your businesses, etc. But this is one of those key ones where an employer is able to say, yeah, whistleblowing, fine, we don't care. Great, thanks for letting us know. Brilliant. We want an open culture, but don't do it in this way. And don't undermine your relationships with key individuals where you can't then continue to work. So Tom, click me on to the next slide, please. So I'm going to look a little bit about anonymous whistleblowing as well. So anonymous whistleblowing, clearly, and you can probably see from all that case law, the descriptions that Fiona gave as well, making a whistleblowing disclosure, it involves a real significant level of risk for that employee. Best case scenario, they make a disclosure and the employer goes through it appropriately, upholds it, and everything's happy and hunky-dory. Obviously, as lawyers, we don't tend to see things when they're happy and hunky-dory. We see them when they're going wrong or they're going sour or there's been a disapproval about the way that something has happened. So there's a risk for any whistleblower, the risk of detriment, dismissal, reputational damage, and obviously financial loss that comes from that as well. They may write themselves into a couple of years worth of litigation to be able to get to a remedy. So the need for this, or the idea that there should even be something like an anonymous route to be able to whistleblow, kind of strikes to the heart of that difficulty from the outset. Because if there wasn't a fear of retaliation or negative connotations, there wouldn't be a need for an anonymized route. So an anonymous whistleblowing disclosure is where someone has no identifying information and they make a disclosure to you. It could be via a burner email address, something posted anonymously on a chat website or submitted to a kind of a hotline, anonymous hotline. But and employers can decide whether they will accept anonymous disclosures. And it's key for them about whether or not in their policy they'd say, well, we always want people to be able to put their name on disclosure, to tell us information about what's happened, what their identity is, because it facilitates feedback to them. And there's a difference between an anonymous disclosure, i.e., no identifying information, and information that's provided on a non-anonymized basis that is then held confidentially. And so a lot of whistleblowers, they would like the preference of being able to do it anonymously because there's no personal risk to them taking that step. Employers might consider that and go, anonymous whistleblower, man. I mean, what are we supposed to do? How can we look into something when we don't even know that person's name, that person's details? And again, a lot of times disclosures, they're going to be pretty specific, as Fiona said. Like, it's what's in the mind of that person at the time, whether or not it's a reasonable disclosure at all. They can have specialist knowledge to understand it. How on earth are you going to be able to look into that and investigate it appropriately without knowing the substance or the background to it? But the principle here really is if you've got enough information to be able to investigate and it's come through anonymously, fair enough. You probably should be looking at investigating it if you can. You want to understand what potential failings are going on within your business. Maybe we shouldn't be on a principle where we just kind of discount them outright. But that very much goes to degree. If it's just an obvious statement that you can't look into, there's no detail provided to it, then you can take the decision to not undertake any investigation there as well. If that person is, well, I raised it anonymously, they didn't know it was me, but they didn't do anything about it, that then gives them the ability to make a wider disclosure outside of your employment to a prescribed person. So as Fiona said, to the regulators, etc. It can well be also that depending on the style of your business or the sector that you're in, that you're obliged to look at anonymized disclosures, or you're obliged to have a hotline that's available. Certainly within financial services, you're obliged to do that. Places like Ofsted, so for any care homes that care for children or that go through schools as well, Ofsted take those complaints and they completely subject them to confidentiality, and then they'll tell the employer very limited information. So that's the employer, in essence, getting anonymized disclosure, but from a regulator directly. And they are obliged to look into that request because it's been made to them by a regulator. So it can be the business takes the decision to, have that process available, say we could anonymize this for you. My view personally is that I don't think that's appropriate. I don't think anyone should be encouraged to put in anonymized disclosures. What they should be confirmed to, or they should be protected on, is making sure that they are able to raise confidential disclosures and that they will be protected on that basis and that their details won't be passed out to everybody else. So then finally for me, just one last slide. It's about disclosures by non-employees. Thank you very much. I've turned that slide over. So legal protection, it applies specifically to workers. Worker, employee, you got a protection, no harm, no foul. Job applicants, not generally protected unless they're applying for NHS roles. Volunteers, contractors, they're not currently protected either from being detrimented or dismissed because they can't be subjected to dismissal because they're not employees or workers. Trustees, they can be protected depending on their contract, whether they're deemed to be workers. Same as franchisees, they could be protected. So it's worthwhile kind of considering the legal test around worker status and whether they're doing that work personally. Carers who aren't workers, nope, not protected. But there's sector-specific rules. So financial services, the FCA and the PRA rules require firms to have whistleblowing arrangements that mean that they're capable of dealing with disclosures from any other person, not just employees. That's all from me. I will pass it over to Matt for the final points of the slide.
Thanks very much, Toby. Brilliant. Thanks, Tom. So one of the issues that we wanted to cover off, which we've had some queries about recently has been around global whistleblowing policies. So if you're an international business, you will want to have a whistleblowing policy in place. A number of reasons for that. As I mentioned at the outset, you may well see the benefits of having a transparent culture. If things are going wrong within your business, you want to know about them and you want to be able to address them before things go drastically wrong or before, particularly if things are happening unlawfully, you will want to know about them. So you want a transparent culture across your business. Also, in terms of managing your risk, Fiona and Toby have outlined there all of the risk to employers that applies in the UK in relation to the way in which we treat whistleblowers. So as a business, you will want to manage that risk and have guidance for managers on how they deal with whistleblowing, both from an investigation point of view, from the transparent basis, but also in terms of avoiding legal claims from whistleblowers. And the challenge for international businesses is that the standards and the protections are not the same across the world. There are different standards of protection, different terminology. So what do you do in terms of implementing an international policy? Do you have, and we've seen in all of these approaches, you could have a single policy that sets the threshold at the highest standard for all. So if you look at the way in which whistleblowing is defined, it will be defined differently in different jurisdictions. Do you set a standard across your business that says, well, we will take the widest possible definition of whistleblowing and apply that across all our entities? And anyone who falls within that definition will be deemed to be a whistleblower for our internal purposes and protected, even though on the basis of their national laws, they might not technically be a whistleblower. So that's one policy. Another potential is to set thresholds. Sorry, Tom, can you slip back to the previous slide, please? Another potential is to set thresholds not at that highest standard, but at a medium standard, if you like, but to have appendices that have local variations. To say, we define a whistleblower as follows, except in the following jurisdictions, which are dealt with by their own appendices. So that's a slightly more complex policy, more variations to it, but is at least clear and is giving people the protections that they require in their own jurisdictions. A third potential approach is, again, a single policy, but is based on the law that applies on the jurisdiction in which the majority of workers are located. So if 90% of your workers are based in the US, then you might take the view that, well, our policy will subscribe to the US system, and to the extent that there are variations for the 10% of workers, we think we've managed that risk. There might be some local guidance, but we will try and set the standard across the board at the US standard or at the UK standard or wherever it may be. And the final example would be to just say, this is too complicated. We're not going to have a single policy and we're going to have autonomy within the regions and each organization. There will be a mandate that each organization needs to have an appropriate policy. And you could, for that basis, be mandating your local HR managers by saying, look, your policy must fulfill the following criteria. It must encourage a transparent culture. It must provide protection for whistleblowers in accordance with your local laws, and it must manage the risk to the business in relation to the way in which whistleblowers are treated in your local law. All of them are legitimate approaches. There is a strategic discussion to be had about which approach to take if you are an international business. The other thing, just to flag on that, when we talk about global whistleblowing policies, I think there is a discussion about use of the term whistleblower. I'll come on to potential reforms in a minute. The term whistleblower is a loaded term in itself, and I know there is a bit of an agenda around should we be trying to change the terminology in order to change the way in which we approach these things. Next slide, please. Okay. So the future of whistleblowing, which I trailed at the start, a number of things to mention here. The first thing is under the Employment Rights Bill and the government's roadmap for implementation. Of course, the bill hasn't had royal assent yet. Some of you will have seen last week some further confusion added to the mix by the resignation of Angela Rayner and some suggestion that that means that the bill might get watered down in certain areas. Government have indicated that that won't be the case, but we genuinely don't know where we are because there's still a lot of unknown elements to the bill. But at the moment, the roadmap for implementation says that with effect from April 2026, there will be an addition to the Employment Rights Act to those categories that Fiona set out of what can constitute a protected disclosure, so a breach of a legal obligation, health and safety disclosure, etc. Added to that will be a complaint of sexual harassment. Now, if you make a complaint of sexual harassment at the moment to your employer, you're already protected against victimization under the Equality Act. So in theory, you shouldn't be subject to a detriment or a dismissal because you have made a complaint of sexual harassment. What this does, however, so you might say, well, what does adding it to the list of protected disclosures actually do for the employee? What are the impacts of this? Well, there are a couple of potential impacts. One is it opens up the possibility of interim relief, which Toby mentioned. So if I make a complaint of sexual harassment, as a result of which I'm dismissed, I can, within 7 days of that disclosure, of that dismissal, make an application for interim relief. I can't do that at the moment. You can't do that for a victimisation claim under the Equality Act, but I could do under once it becomes a protected disclosure. What it also means is for those in regulated sectors, such as financial services, where they have a particular whistleblowing framework, whistleblowing procedures they need to adopt, etc., then they need to ensure that that now includes complaints about sexual harassment, which significantly widens the scope. So that is something, can't promise it will happen in April 2026, but based on the government's current intention, that is the intention. Organisations, of course, as you'll be aware, since October 2024, have a duty to take reasonable steps to prevent sexual harassment in their workplace anyway, by implementing policies and training. Part of that duty, in terms of the guidance around that, is about having appropriate complaint mechanisms in place and having appropriate protection in place for those who complain. So it falls within that duty as well. The second potential reform on which there's been some discussion is the introduction of financial rewards for whistleblowers. This is something that happens in financial services in the US. For those of you interested, it was a couple of years ago, 2023, the highest award given to an individual whistleblower was $279 million because it works on a percentage basis. So if, as a result of whistleblowing, a penalty is levied on an employer, then an individual can get a reward of between 10 and 30% of that penalty. So, and that's for any awards over $1 million in the US. Now, there are a number of issues with this. Somewhere like financial services is the obvious area for it because there would be financial penalties. It might not be appropriate in sectors where there aren't financial penalties. So public sector organisations, so for example, whistleblowing in the NHS, you're not going to be able to offer to pay someone £200 million for whistleblowing in the NHS because where does that money come from? The whole point of the US system is the reward comes from the penalty. There's a debate about the effectiveness of it, because whilst it does provide an incentive to whistleblow, a very clear financial incentive to whistleblow, What it also means is if you are putting your neck on the line and you're coming forward with a whistleblowing, you are going to be liable to the defense that you are doing this or making this up because you're trying to do it for financial gain. So on a risk reward basis, whilst there is the potential reward, it also increases your risk. You're no longer seen as altruistic necessarily or genuinely raising it. But it is something that we know is being explored by the Serious Fraud Office and by HMRC. Whether it happens or not, I don't know. But it's an interesting thought. The third thing I wanted to mention, there was a private members bill introduced in Parliament in 2024 seeking the introduction of an independent office of the whistleblower. And it was due to have its second reading earlier this year. That's now been postponed until May 2026. And it is not dissimilar to suggestions in the Grant Thornton report that I mentioned earlier around the potential about looking at some form of independent whistleblowing office. So at the moment, EHRC, for example, looks at equality complaints and can go into a business, and if a business is discriminating against employees or harassing employees, can take action in relation to that. At the moment, if you whistleblow, then your regulator might be interested in the whistleblowing and the substance of it, i.e. the complaint that you are making, as Toby referred to Ofsted or Ofcom or whoever it is. But there is no single independent office interested generally in incentivizing and protecting whistleblowers. So it's a private members bill. Private members bill don't often become law. Sometimes they do. But what they can do is generate discussion and consultation. And there is certainly some suggestion that in order to achieve the purposes that I mentioned at the outset, that it's possible that we might in future have an independent office of the whistleblower. At the moment, the government has a lot on its plate in terms of the Employment Rights Bill, so I don't anticipate this happening in the next 12 or 18 months, but it's possible it happens in the future. So we've just got a couple of minutes, Fiona. I don't know whether we've had any questions in that we need to deal with.
Hello, sorry, just fumbling to get my camera back on. Well, we've had one comment saying great insights. One observation about different jurisdictions in some countries, Germany do not advocate whistleblowing. So just putting that out there. In terms of questions, probably one for Toby. If a claim is made against a company and individual, can the claimant settle the claim against the company but continue against the individual?
Oh yeah, definitely. Yeah, I mean it's one of those you can have that split sort of trial. It'd be a bit strange to sort of see it be entirely separated, especially if the managers within the company are fairly senior who are involved in it. But yeah, definitely, yeah, you could definitely settle it out on that basis. What would be super interesting, I guess, is if the employer said, we're going to pay you a really nominal sum because we don't think we're liable for anything. It's these bozos, and sort of took everything back or took the guys under the bus to see kind of what happens with it. But yeah, as a principal basis, yeah, you'd be fine with that.
Good stuff. And maybe one more. Do you think, Matt, have I got time?
Yeah.
Um, if an individual only whistleblows because they have a grudge against the company, for example, they've been disciplined, does that still have to be dealt with as a whistleblowing?
That might be for you, Fiona. That one, yours?
Yes. In short, there doesn't have to be the requirement for kind of goodwill behind it has been removed now. So even if we suspect, I suppose that might be taken into account in terms of compensation, but yeah, we still have to look behind it, even if there is, we have concerns about the intentions behind it. We should still look into it. Okay.
Okay, thanks, Fiona. I think that's us pretty much bang on 11 o'clock. So we'll finish there. Thank you very much for attending, everyone, and have a good rest of your day.
Thank you.
Thank you.